All right, hello everybody. In this presentation, we're going to talk about the judicial system in the United States, and we're going to talk about sort of the structure of the judicial system, and then also talk about some terminology and talk about how cases basically go through the various judicial systems in the United States. But we begin by first acknowledging that there are in fact 52 court systems in the United States. There is the U.S. federal court system, which we're going to talk about here, and there's also 50 individual state court systems, plus there is the District of Columbia or D.C. court system. So the point here is we have essentially 52 different systems of courts that exist in this country. In this class, for the most part, we're going to be talking about cases that come through the U.S. federal court system. However, on occasion, we might talk about a case that involves a state court system. So we also need to consider the difference between trial and appellate courts. So some courts are trial courts and some courts are appellate courts. A trial court is going to be where a case begins. So, for example, if somebody is arrested for murder and they're put on trial, that would be held in a trial court because that would be where the case begins. If somebody sues their neighbor or sues anybody else in a civil case, the court where that trial begins is going to be a trial court. And so essentially trial courts are where cases begin, and then appellate courts are appeals courts. So appeals courts are where cases go to when one party or the other appeals. And in most cases, when you have especially a civil case, and also when you have a criminal case, if you lose, you can appeal. So essentially, if you don't like what that court decided, you can appeal. And then that goes to an appellate court, and there's a chance that the appellate court might rule differently. So one more thing to consider about courts in the United States, and actually courts anywhere, is the concept of jurisdiction. And jurisdiction essentially just means the power to hear and rule in a case. In a lot of situations, jurisdiction is based on geography. So for example, there are courts in Ohio that basically hear cases that originate in Ohio. Other courts' jurisdictions are based on subject matter. So in the federal system, for example, there are tax courts, which basically just hear cases involving tax disputes. So talking about the federal court system, it's probably a good idea to begin with the Supreme Court. The Supreme Court of the United States, which is sometimes abbreviated SCOTUS, S-C-O-T-U-S. So if you ever hear anybody using the term SCOTUS, that's what they're talking about. The Supreme Court is essentially the highest court in the land. You probably remember from government class in high school that if you lose at the Supreme Court, there is essentially nowhere else to go. And that is very much true. So the Supreme Court is actually made up of a Chief Justice and 8 Associate Justices. And this is what the Supreme Court looked like up until a couple of months ago. And so the members that we had in the Supreme Court were Antonin Scalia, who was appointed in 1986 by Reagan, Anthony Kennedy, who was appointed in 1988 by Reagan, Clarence Thomas, who was appointed in 1991 by President George H.W. Bush, Ruth Bader Ginsburg, who was appointed in 1993 by Bill Clinton, Stephen Breyer, who was appointed in 1994 by Bill Clinton, John Roberts, who is actually the Chief Justice of the court was appointed in 2005 by George W. Bush, so the second George Bush. Samuel Alito was appointed in 2006 by George W. Bush. Sonia Sotomayor was appointed in 2009 by President Obama. And Elena Kagan was appointed in 2010 by President Obama. And of course, what has happened in the last couple months here is that Justice Scalia passed away. And so what we have now is we've got this very big political fight going on, and I'm not sure if you've been following it, but you probably should be, especially if you are a budding journalist. So essentially what's happening here is the way the Supreme Court works is the president gets to pick who is on the Supreme Court, but the Senate has to approve that pick. And so President Obama has appointed somebody to basically take Scalia's place, but the Republicans in the Senate are essentially saying they're not going to do anything about it, where their argument is that since this is Obama's last year in office, that he shouldn't get to pick the Supreme Court nominee, and that instead, as they say, we should let the people decide and essentially wait until a new president is elected. So this is a concept that's been talked about before, but has never actually been done. In other words, even though Democrats in the past have talked about doing something like this, they ultimately did go through and approve Republican nominees for the Supreme Court. But it's going to be interesting to see how this actually plays out and how much political pressure gets put on the Republicans to basically do what they're supposed to do, which is act to approve the president's appointee to the Supreme Court. Now, the reason this is such a fight is, first of all, the Supreme Court, as we talked about, is the highest court in the land. So if you've got somebody on the Supreme Court, that is a very, very, very powerful position. And, we've already seen how Supreme Court decisions can affect legislation, can affect things presidents want to do. There have been all the challenges to Obamacare, for example. And so, again, it's hard to overstate the power of the Supreme Court. The other thing about the Supreme Court is that once you're on the Supreme Court, you can more or less serve for life. So essentially, you don't need to worry about getting reelected. You don't need to worry about being reappointed. You can essentially serve for life. And John Roberts, incidentally, the Chief Justice, is a relatively young guy by Supreme Court standards. I think he's in his early 50s. And so he could conceivably be Chief Justice of the Supreme Court for perhaps the next 30 or more years. And so again, it's a very unique position to get appointed to. It's a very powerful position, and that's sort of why we are hearing a lot of the political discussion about it. Related to this, we get into talking about the liberal versus conservative members of the Supreme Court. And so the liberal members are considered to be the two Obama appointees, Elena Kagan and Sonia Sotomayor, and Ruth Bader Ginsburg, and Stephen Breyer. And the conservative members of the court are essentially Roberts, Scalia when he was still alive, Alito, Clarence Thomas, and to an extent Kennedy. And I've actually positioned them on this slide here according to how liberal or conservative I think they are. And so the further left somebody is, the more liberal I'm saying they are, and the further right they are, the more conservative I'm saying they are. And this is actually just my opinion, although actually if I were really giving my opinion, it would probably look something like this, because Scalia and Clarence Thomas are both really, really, really conservative. But once again, this is just my opinion for the most part. So again, the Supreme Court is highest court in the land. It's a very important appointment. So one of the other things to understand about the Supreme Court is that it has more or less complete autonomy in choosing what cases it wants to take. So even though they get thousands of requests to take cases each year they only actually take a small number of those. And so, essentially they only end up hearing like 150 or 200 cases a year. And we'll talk more about how this process works as we actually talk about some specific cases. But essentially, when you appeal to the Supreme Court, you're essentially going to put together legal briefs, explain your case, explain why you think the lower court has made a mistake, and then you're basically going to hope that the Supreme Court issues what is called a writ of certiorari. And the writ of certiorari is essentially the Supreme Court saying, yes, we will hear your case. And so again, if you're in a situation like that, that would certainly be what you would want to have happen. You would want to have the Supreme Court hear your case. So now, talking about some of the lower courts in the United States, this chart more or less shows the United States court system. So we have the Supreme Court of the United States at the top. We've got underneath that the appeals courts. And so we have the U.S. Court of Appeals, and there are 12 circuits, which we'll show a map of those here coming up. And then we have the Court of Appeals for the Federal Circuit, which deals with some of the very specialized cases that we talked about. And then we have the U.S. Court of Military Appeals, which deals with military issues. So that second row with the three courts and also the Supreme Court, both of those are considered appellate courts. So the courts of appeals and the Supreme Court are appellate courts. And then down at the very bottom in the third row, we have essentially the trial courts. So we have district courts underneath the appeals courts, and we'll talk about those here in a bit. We also have the U.S. Tax Court and then some other specialized courts. So, once again, the big thing to understand about this slide is that our trial courts are on the bottom row, and then the top two rows are essentially the appeals courts. Okay, so this is showing us a map of the district and circuit courts. And, once again, remember the circuit courts are the appeals courts. And we actually have a total of 13 circuits. 11 of them are based on states. And then we also have one that is for the District of Columbia. And then there is an additional 13th court that deals with patent and trademark cases. So you can see here on the map the 11 geographic appeals courts. Ohio, Michigan, Kentucky, and Tennessee are actually in the 6th district. Then if you look a little bit closer, you can actually see that the individual states are divided up as well, because this is showing us the district courts. And the district courts are the federal trial courts. And so you can see in the state of Ohio, we actually are divided into a northern district and a southern district. And then in Michigan, it's divided into an eastern and a western district. And so again, you can look at some of the other maps and you can see that a lot of states actually are just a single district. It's based a lot on population. But again, these are showing us the actual district courts, which once again are going to be the trial courts. So then looking at the Ohio court system, we have a sort of similar structure where we have the Supreme Court of the state of Ohio, which has a Chief Justice and 6 justices. We have 12 courts of appeals, and then we have the courts of common pleas, And those are divided into different, like general division, which is going to be, sort of general cases. Domestic relations. Probate is going to involve things like inheritances and wills, and juvenile division. And then we also have, depending on where you're charged with a crime or where you're suing somebody, you have mayor's courts that are in some cities, you have county courts, and you also have municipal courts. And you can see here from the graphic that all of these courts that are sort of underneath the Court of Appeals, they all feed into the Court of Appeals. And once again, this is this idea that you're going to start in one of these courts that is basically below the Court of Appeals, and then if you don't like what happens in that court, you would appeal to one of the Court of Appeals. And then if you didn't like what happened there, you could appeal to the Ohio court system. And then if you didn't like that, you could appeal to the United States Supreme Court. Although, as we just learned in the last slide, they're very particular about what courses or what cases they are going to take on. So one other important thing to talk about courts, it's this concept of judicial review, where we talked about before, where in a lot of cases courts are going to be the ones to decide whether something is constitutional or not. And so that's going to be a lot of what we talk about in this class, where it's going to be a court deciding whether a certain law violates the Constitution, specifically in this case, the First Amendment. So just kind of keep that in mind. Okay, and then we have essentially two types of law. We have civil law, and this is basically going to be things that we consider lawsuits. And this is essentially what happens when two private individuals have a dispute and one of them takes the other to court. And I shouldn't even necessarily say private individuals, because it could be an individual versus a company. It could be one company suing another company. But the point here is that in civil law, the government isn't actually one of the participants in the case. The government is essentially just providing the forum to basically decide the case. So the plaintiff in a civil law case is the person who initiates the suit. So if I sue my neighbor, I am basically going to be the plaintiff, and my neighbor, the person being sued, is called the defendant. And what happens here is we basically go through this process where I would file a civil complaint against my neighbor. We would have a pleading where basically each of us would sort of give our cases, and then it would basically be scheduled into a court system. And if we can't sort of come up with something to kind of do away with our differences, we might actually have to have a trial. And then what can happen is, based on that trial, the party that wins is going to receive damages. Because once again, civil law is going to be about things like, you backed into my car, or, your tree fell on my house, or, whatever the case may be. And so, again, the way that we are going to remedy those civil law cases is not by putting somebody in jail, but we're basically going to award the winning party damages. And then, as we mentioned, we can also have appeals in civil cases. So then, talking about criminal law, the difference here is that the state is the plaintiff. So rather than both the plaintiff and defendant being private parties, the state is essentially going to be who is initiating the suit. So this is, for example, the case of the People versus O.J. Simpson. When we say the people, or the state of Ohio, or the state of Michigan, that is basically saying that this is the government of this state or this, whatever jurisdiction we're talking about is basically bringing an action against somebody for a crime. So that's the plaintiff, and then the defendant is essentially going to be the person accused of the crime. And once again, as we talked about the People versus O.J. Simpson, when we actually give the official name of a case, and we'll talk about this later in the semester, the official name of a case, we give the person initiating the case first and then the defendant second. So the People versus O.J. Simpson is essentially representing that the state is accusing O.J. Simpson of a crime. So what will happen in a lot of cases in criminal law, although it varies, is a lot of times there will be an indictment. And an indictment is basically handed down by what's called a grand jury. And a grand jury is a jury that meets in secret. And what happens in a grand jury is prosecutors will basically bring in evidence about various cases. And if the grand jury believes that there's enough evidence to basically indict somebody and potentially put them on trial, that's what they do. They issue an indictment, and when you are indicted, that essentially means the grand jury thinks there's enough evidence against you that we at least have to look into this and probably have a trial. So then what would happen after that is there would be an arraignment at which you come in and you're read the case against you, and then you can either plea bargain or you can have a trial. And if you plea bargain, you see this a lot of times on cop shows on TV. A plea bargain would be you might plead guilty to a lesser charge and don't go through with a trial. But once again, if you don't want to do that, you can actually go through with a trial. And then once again, we can also appeal these kind of cases. So one of the other big differences between civil law and criminal law is the standard of proof. And I'm going to actually talk about these in reverse order that they are on the slides. But in a civil case, essentially, in order to win, you have to prove a preponderance of the evidence. And what that means is essentially you have more evidence on your side than the other person has on their side. Okay? And so it just literally means you just have to have a little bit more evidence than the other person. That's a civil trial. In a criminal trial, in order to be convicted of a crime, the jury or judge, depending on the situation, has to believe that you have been proven guilty beyond a reasonable doubt. And that essentially means that, yeah, there's a slight chance that maybe you didn't do it, but it pretty much looks like you did it. A reasonable person, after seeing the evidence, would not doubt that you actually committed this crime. And if you think about that, that's a much harder thing to prove than just to have a little bit more than what the other side does. But that's on purpose, because one of the things that we stand for in this country is, we don't want to put innocent people in jail. And so even if that means that we might let an occasional guilty person go free, the last thing we want to do is actually have somebody who's not guilty be convicted. Once again, having said that, we do have that happen, every day in this country. But this is, again, just the difference between the standard of proof in a civil case versus a criminal case. So then when we talk about an appeal, so when you appeal a case, you become what is called the appellant or the petitioner. And again, this is the party seeking the appeal. So I sued my neighbor won at the trial court, and so now I'm suing, I'm basically appealing. And so I'm going to be the petitioner. And then the appellee, or also called the respondent, is going to be the other party. So in this case, my neighbor. And you know, once again though, it sort of depends on like who is the person suing. Because let's say I sue my neighbor and I win. Well, then I'm probably not going to want to appeal because I won, but my neighbor might appeal. So if my neighbor appeals, then, you know, they become the appellant and I'm the appellee. And what can happen on appeal is a court can actually affirm what the lower court decided. It can reverse what the lower court decided, or it can remand. And when it remands, what it does is the court essentially sends the case back to that court and essentially says, try again. So essentially what they do is kick the case back and they say, you did something wrong here and here and here, fix that and try again. Okay, so this has been our presentation about courts. I hope you enjoyed it as much as I enjoyed creating it.